10384. Mr. Hernandez is present in court. Can all the parties please identify yourselves for the record?
Good morning, Your Honor. Patrick Hagan for the Commonwealth.
Good morning, Your Honor. Teresa Anderson for the Commonwealth.
Good morning, Mark Lee for the Commonwealth.
Ronald Sullivan on behalf of Aaron Hernandez.
Linda Kenny Bond on behalf of Aaron Hernandez.
Good morning, Judge Michelle Medina on behalf of Aaron Hernandez.
Good morning, George Lee on behalf of Aaron Hernandez.
All right, good morning, folks. In terms of my giving the charge yesterday, for the most part, it tracked the written instructions that you had been provided. There were some differences in phrasing as I delivered it, and so what I would intend to do is simply insert those changes into the written product so that the written instructions actually track what was said. We've got a fairly good set of notes as to what those changes were. It may have been inserting an "and" instead of a "the" or something of that sort. And so I'm going to have those changes made such that the written instructions that go upstairs do in fact mirror what was said. And I think we have our jurors ready to come down to complete the instructions relating to the deliberations. And then we'll send our jury out to deliberate. Is there anything either side has to address before we get our jurors down here?
Yes, Your Honor. We think the court should question the jury foreperson on information and belief. Her name was widely spread among the media last night after it was announced in jury instructions. And we think the court should ascertain whether she's been contacted by media or anyone else, frankly, after her name was released.
Well, I think I've said that each and every day of this trial, and I'd say the same thing today.
We think she should be individually questioned, given the nature of the widespread release of the name, as opposed to the general statement that Your Honor gives every morning.
And why is that?
Because we think that there's a special cause to think that this witness has been contacted by...
Do you have any reason to believe the witness has been contacted?
Yes, she's all over Twitter, all over the internet.
You've said that. Do you have any reason to believe she has actually been contacted by anyone?
That is my reason.
That's the basis.
I'm making an inference from the fact that so many media know her name, and given my experience with my wonderful friends back there, that media tends to contact folks.
All right, I'm satisfied the inquiries I make each day will suffice. Anything else?
I'll just add for the record, there were some tweets that said that the foreperson was, quote, easy to find. To infer from that, then, that she was, in fact, found.
Tweet? Okay.
Tweets, messages on the Twitter application.
By reporters, editors, producers?
By people.
By people.
On Twitter. So I don't think it matters whether other individuals are contacting her or the media. I think there's a likelihood that both.
No, I ask only because you said you're familiar with that crew in the back. I didn't know whether you were accusing them.
Oh, I never accused them of anything, Your Honor.
All right, let's line our jurors up, bring them down.
All right.
14-104-17 and 15-103-84. Mr. Hernandez is present in court, represented by attorneys Jose Baez, Ronald Sullivan, George Leontire, Linda Kenny Bond, and Michelle Medina. The Commonwealth is present, represented by Assistant District Attorneys Patrick Hagan, Mark Lee, and Teresa Anderson. Good morning, Your Honor. All 12 members of our deliberating jury and our 3 alternates are present.
Okay, good morning. Good morning, folks. Let me inquire of all jurors, both those now selected as alternates and the soon-to-be deliberating jurors, whether, since yesterday when you left the courthouse, any juror has discussed this case, has read, heard, or seen anything about this case, or has had any contact with the case outside of court? If you have, would you raise your hand? And I see no hands raised. And just to supplement that request, since you left yesterday, whether any juror has been approached by anyone or had any communication by anyone regarding this case. If you have, would you raise your hand? And seeing no hands raised, I find this jury remains indifferent. And let me conclude the instructions that I provided yesterday. I had suspended talking about the deliberations and the manner of deliberations, giving some instructions with regard to your deliberations, and I want to complete them. And let me state to all, but in particular to our foreperson, that after the jury has assembled in the jury deliberation room, the court officers will deliver to you all of the exhibits and as well the verdict slips that you will use and a copy of these instructions. When the jury has reached its unanimous verdicts, our foreperson should record that verdict on the verdict slip and date and sign it, and then inform the court officers that you've reached a verdict and you'll be brought back into the court to deliver that verdict. There are 8 verdict slips in this case relating to the 8 separate charges. And the verdict slips reflects the unanimous decision of the deliberating jury and reads in part, "We the jury find the defendant," and then offers choices. For the first count of the indictment relating to July 16, the verdict slip relates to the death of Daniel De Abreu and states, "In the above entitled case, we the jury say the defendant is," and then offers 3 choices. Choice number 1, not guilty. Choice number 2, guilty of murder in the first degree. And if that is the unanimous verdict of the jury, you are then to indicate which theory of first degree murder you find, or whether you find both theories of first degree murder, and they're set forth on the verdict slip beneath the first degree murder box, indicating a theory of deliberate premeditation or a theory of extreme atrocity or cruelty. And as I've told you, you should consider both theories and determine whether or not the Commonwealth has proved the defendant's guilt beyond a reasonable doubt on either or both of those theories. And then the third choice is guilty of murder in the second degree. So those are the choices as to the verdict slip for Mr. De Abreu. As to the second count of the indictment charging murder of Safiro Furtado, there are 3 choices: not guilty, guilty of murder in the first degree, recalling that the theory for the death of Mr. Furtado is solely deliberate premeditation for first degree murder, or guilty of murder in the second degree. And then as to all other verdict slips, there are merely 2 choices. Choice number 1, not guilty. Choice number 2, guilty of the offense as charged. Each verdict slip lists the offense at the top of the form, indicating as to the 3 separate armed assault with intent to murder, the alleged victim relating to each separate count. So in count 3, it relates to Gerson Lopes. Count 4 relates to Rashides Sanchez. Count 5 relates to Aquilino Freire. And as I indicated, when the jury has reached its unanimous verdict as to each of the separate charges, please note that, Madam Forelady, on the verdict slip, and then date and sign the verdict slip and notify the court officers. Now understand, during your deliberations, no one will inquire as to what you're discussing. Your deliberations are secret to you and to you alone. No court officer, no clerk, no judge will ask you what you're talking about or where you stand. That is your business, not ours. The only inquiries that will be made during the course of deliberations will relate to whether you want to take a pause to have lunch or refreshment, and at the end of the court day, indicating somewhere around 4 p.m., whether you would like to suspend deliberations at 4 o'clock, or whether you think with a little more time you might be able to decide this case, in which case I'd be inclined to keep the court in session beyond 4 o'clock. But it's not asking you what you're talking about or where you stand, merely whether you'd like to recess or continue deliberations, and I'd likely be guided by your choice. If during the course of deliberations you, the jury, have any questions for me, I'm going to ask our foreperson to write out that request or that question on a piece of paper, date it and sign it on behalf of the jury, and deliver that note to a court officer that will bring it to me, and I'll deal with it if and when it arises. As well, as I indicated yesterday, Madam Forelady, if during the course of deliberations there is any mention of or reference to information or material that was not part of the evidence in this case, you are to suspend your deliberations and notify me of that extraneous information or material so that I may deal with it as necessary and appropriate. One last issue that I have to address relates to electronics. During your deliberations, and you're going to hear this in just a moment, when our court officers take an oath, you are sequestered from the outside world. The court officers are going to take an oath to take you to some convenient place. It happens to be the jury room upstairs. And that they will suffer no person to speak to you, nor you to speak to any other, until you have reached your verdicts, meaning you're sequestered from the outside world. How many of you have cell phones? Okay. Do you see the potential problem there? I'm going to ask that you surrender your electronics during deliberations. Our court officers will safeguard them and give them back to you at the end of the day, but it is simply to ensure that there is no communication while you are deliberating as a group. With all of that said, by way of final instructions, Mr. Sheehan, if you would swear the court officers.
Do each of you solemnly swear you'll take charge of this jury and keep them together in some convenient place so that you do not speak to them yourself, nor suffer anyone else to speak to them, unless it is by court order or unless it is to ask if they have agreed? So help you God?
All right, the jury may retire to deliberate.
All right, please.